Welcome to the Legal Notepad. If you're an attorney, I have a special editor's note. This note has been added after the recording of the episode. The podcast, the episodes, they're always free. However, if you want CLE credit, the Kentucky Justice Association has submitted the podcast to the KBA for CLE credit. In order to get credit, simply go to KentuckyJusticeAssociation.org, click on the Education and Training tab, then click on Podcast and add it to your cart. That being said, let's jump into our episode.
I want to read you an email I received recently from one of your listeners. Dear Kevin and Rob, I have a case set for trial next month, and the defendant wants to stipulate that their driver caused the motor vehicle accident. And because of that stipulation, they want to keep a lot of evidence out of trial.
Welcome, everyone, to Episode 3 of The Legal Notepad. As you know, my name is Rob Mattingly, and I'm here today with my great friend Kevin Burke and my amazing paralegal Lauren Hincks, who you just heard read our question of the day. Kevin, Lauren, thanks for being here. I'm really excited today as we transition the podcast to cover a single legal issue. And in each future episode, we're going to address a single legal issue and then have Kevin Burke guide us through the answer. So, Kevin, I won't ask you to describe your background and your qualifications in every episode, but as this is your first time on the show, why don't you tell our listeners just a little bit about yourself?
Well, first, Rob, and it's great to be here with you and Lauren. I just am so excited about this, where we dial into a specific issue of law and really talk about it, and hopefully this will help folks listening handle these situations a little better. But just to tell you a little bit about myself, I handle mostly Kentucky appeals. So I focus my work in the Kentucky Court of Appeals and in the Kentucky Supreme Court, but I also help out trial attorneys at the trial level with briefing and strategic issues that pop up. So, my typical day involves, a lot of briefing, a lot of writing, but it also involves the random text or the email, the bat signal, let's say. So
I've sent you a couple of those, Kevin.
I have gotten a few from you, yeah, and those are immediate concerns where somebody, says something, for instance, I'm in trial, and somebody, the defendant has argued this issue. What do I do? So those issues require immediate concern, an immediate answer. You'd have to drop everything else you're doing and try to work through that with the person who's contacted you. And I really enjoy it. I mean, sometimes there are very unfortunate situations, but we work through it and it really works out. I really enjoy working through problems with other folks.
So, Kevin, why don't you tell us a little bit about your background?
Yeah, so I've been practicing now for about 25 years, and I started out as a solo practitioner, did a little bit of everything, so you know how that goes. When any kind of case that comes through the door, you take it, and I built on that experience and eventually started handling appeals on a regular basis. And about 7 years ago, I teamed up with Jamie Neal, my partner.
Love Jamie.
Jamie is great, and she really helped. I mean, we work on every case together, and that kind of back and forth where you work through legal issues, I mean, really critical legal issues with somebody else. I really didn't realize what I was missing before her. And now we've kind of, with Jamie, we were able to take it to the next level and really help out a lot of people and really tackle important issues that we handle on appeal.
Well, as you and I got together and we talked about doing this series of podcasts, and again, we're going to be talking about a lot of different single-issue episodes to really help the younger lawyers, well, all lawyers, but certainly the younger lawyers as they need to know this before they go into trial. Let's talk about what we'll be doing. Everyone, you need to remember two email addresses. My email address, robertmattinglyattorney@gmail.com. I know I go by Rob, but the email is robertmattinglyattorney@gmail.com. Kevin, his email is kevin@burkenil.com. Kevin@Burke, B-U-R-K-E, Nil, N-E-A-L.com. Why am I telling you that? Because for every episode we do, we'll have a case file with all the different cases, the briefs, the statutes, whatever it is we're referencing. And if you email either Kevin or I, we will send that to you free of charge. So if you're listening to this and you want the cases, you want to start a trial notebook or a research notebook, just shoot us a quick email and we'll shoot those back to you so you can have those. So the question today is that we're going to address is, can a defendant make a plaintiff stipulate away part of their case? Can they say, for example, we are stipulating liability, and therefore a whole bunch of evidence that you wanted to come in and for a jury to hear is going to be excluded? So can they make you stipulate away a part of your case? And Kevin, what is the answer to that question?
The answer to that question is generally no. They cannot make you stipulate away part of your case.
And this generally, what cases are we gonna kind of outline for the listeners today?
Well, I think the two main cases here, a case called Davis versus City of Winchester, and MV Transportation versus Algar. But for your listeners, let me give the case sites for that. Usually when I talk about cases with other folks, I just use the case name because, you can Google that or put it in Westlaw or whatever. But I do want to give the case number. So Davis versus City of Winchester is 206 Southwest 3rd, 917. And that's a Supreme Court case from 2006. MV Transportation, Inc. versus Algar, that's spelled A-L-L-G-E-I-E-R, 433 Southwest 3rd, 324, and that's a Supreme Court case from 2014.
All right, so it sounds like for our listeners, we're going to cover two cases today, which Kevin and I believe will fully answer this question. So let's jump right into the first case, Davis versus City of Winchester. And I'll tell you what, let me give a little background on the facts. And I won't do much. Kevin will fill in a lot of holes. But generally, the plaintiff had an altercation with some police officers. What happened in that altercation was disputed. That was going to be a disputed fact. But ultimately, the plaintiff, during this arrest, sustained some injuries, and a civil claim was brought. So we are answering this question with a civil case, which is important because for most of our listeners, that's how it'll come up. And the plaintiff brought a couple of charges, a couple of counts. They alleged an unlawful arrest. They alleged excessive use of force, and also a malicious prosecution case. And the case went through discovery, and they ultimately are getting up to trial. And the defendant said, we would like to stipulate away a part of the case. In other words, what the defendant said is, part of the malicious prosecution claim, one of the elements is that the underlying criminal charges, right, this person was charged with a crime, including, this altercation with the police. And one of the things in the subsequent civil case that the plaintiff has to show is that the underlying charge was dismissed in their favor, that they were found not guilty or was dismissed without prejudice or whatever that case may be. And at the civil trial, the defendants wanted to hide that from the jury. They wanted to say, you don't get to tell the jury that the underlying criminal case was dismissed because we're going to stipulate to that element. Of course, the plaintiff says, we don't want you to stipulate to that evidence. We want the jury to hear it. We want the jury to know that that underlying charge was dismissed. And those are generally the facts of the case, and the court had to deal with that. Kevin, tell us what the court did and then how that might apply to our question of the day.
Yeah, and so again, as Rob mentioned, one of the claims that the plaintiff brought was a malicious prosecution claim, and a malicious prosecution claim has several elements, but one essential element is that the criminal charges, the underlying criminal charges, were dismissed or terminated in favor of then the criminal defendant and now the plaintiff. So. What the defendant did, the City of Winchester, they said, it goes to trial, and they say, well, we don't really like the fact that the criminal charges were dismissed. How would the jury interpret that? They would look at it and say, oh, well, why were the charges dismissed? There must not have been any evidence to support it. There must not have been probable cause. And so they felt that that evidence was prejudicial for their client. So they, say, well, here, why don't we do this? Why don't we file a motion to exclude that as evidence? A motion in limine, as most of our listeners know, and so they file this motion in limine and say, Judge, this evidence that the charges were dismissed, that's prejudicial to our client, and we'll stipulate to that. And the trial court said, yeah, that makes sense. We shouldn't have to get into that evidence. And the plaintiff says, hold on just a minute.
We want the jury to hear that evidence.
We want the jury to hear that evidence, but also, Judge, it's essential to our case. It's an element of a malicious prosecution claim. And if we don't introduce proof of that element of the offense, then we've not met our burden of proof. And the trial court eventually said, well, look, I'm going to grant the defendant's motion, but you don't have to prove that. I'm going to give you a pass on that. And that was the issue on appeal. So this gets to the Supreme Court now. And the Supreme Court looks at that and says, well, look, in criminal cases, the criminal defendant can't stipulate away part of the prosecution's case. That's not allowed. And the same should apply in a civil case. So you have an instance where the Supreme Court is borrowing from criminal law and applying it to a civil case. So just for your listeners, that just I try to look when you're researching case law, you tend to look in your lane, right? You tend to look at, I'm just going to look at civil cases. There's a lot to be learned and gathered when you get outside your lane, and that can inform the lane you're in.
Well, let me ask you this then, Kevin. So if they started out by doing an analysis of some criminal cases or relying, I'm going to throw a little sideball at you. Can you come up with the cases that they relied on? What were the cases that they relied on? What were they? Not that we'll get into them a lot. No.
We don't want to get into detail, but they cite three cases. One of which is a case called Barnett versus Commonwealth, and in Barnett, so basically in Barnett, the Commonwealth is trying to prove its case, and they want to introduce some pictures of the victim to show the extent of the injuries. And the defendant says, Judge, we'll agree to the severity of the injuries, so there's no need for the Commonwealth to introduce these gruesome pictures. And the Supreme Court in Barnett said, well, no, you can't stipulate the part of the case, can't stipulate away the parts of the case you don't like that are inconvenient for you, because that's prejudicial to the other side, in fact.
So when the Supreme Court in this civil case needed to come up with a very specific answer to Lauren's question earlier today, can they make me stipulate away to part of my case? The court said, well, you never could do it in a criminal case.
So why should you be able to do it in a civil case? Yeah. And the answer was, you can.
And just so everybody, if they're making a trial notebook or want these cases, the other two criminal cases, you don't need to describe them, but just the case sites for the other two criminal cases, do you have those? Do you have those in front of you here?
Yes. I'd mentioned Barnett versus Commonwealth, and that's 979 Southwest 2nd, 98. But there are two other cases, Johnson versus Commonwealth, 105 Southwest 3rd, 430, and Harris versus Commonwealth, 134 Southwest 3rd. I don't have the remaining part of that site, but it's a 1998 Supreme Court case.
The Harris versus Commonwealth case.
Correct.
Okay, good. So if you're putting together a notebook, you might want to throw those in there. I'll put them in the material in case you want to email Kevin or I, and we can email those to you. So, but let me get back to the story. Kevin was talking about how the Supreme Court had to answer this question about can they make you stipulate an element of your claim. In this case, it was an element of the malicious prosecution. And they said they went through some criminal cases. And then ultimately, Kevin, tell us about the conclusion of Davis. What did they say?
So these are quotes from the case. This is what the Supreme Court says. It says, a defendant may not unilaterally stipulate away from the jury's consideration parts of the case he does not want the jury to see. And that when referring to and looking at these criminal cases, the court said, well, this is the same in the civil context. The same right to present evidence of each element of one's claim exists in a civil action, and the trial court's denial of this substantial right in this case was reversible error. That's important because the court isn't saying this was some, harmless error analysis, for example. They said it's a substantial right to prove each and every element of your claim. So that's important. That's reversible error because, there are all sorts of ways that a court can say, well, even though something was preserved, it might not have affected the outcome, right? So the court could have said, for example, well, look, we understand you didn't introduce evidence that the charges were terminated in favor of the plaintiff, but we don't feel that affected the outcome. Supreme Court could have said that, but it didn't. Instead, they said, no, that is a substantial right. As a litigant, you have the right to prove every element of your claim and have the jury hear it.
Well, that seems so important to me because as a trial lawyer, I'm oftentimes, in court arguing this, and this may come up in a motion in limine prior to trial, but sometimes it comes up at various times during the trial, openings, closing. It just depends on when the defense decides to make it. One of the things I really like to be able to tell a court is, Judge, there's not only a case on point, but the Supreme Court found it was reversible if we do this. And that, I think, has a lot of weight, my experience with trial judges. Judge, this was reversible because they obviously want to have a clean trial. So I think the point that you're making there, that they actually reversed this entire trial because of it, is very, very important.
Yeah, and I agree with you, Rob. If you can show the trial court that this was a reversible error, this wasn't just error that can kind of get swept under the rug. This is something where the court really must follow this rule. There's not any discretion in doing so. And I do want to highlight that this case did have a dissent associated with it. If your listeners read the dissent, they'll see how how it played out with the motion in limine and the plaintiff's counsel having this exchange with the judge. But even with the trial court saying, plaintiff's attorney, I'm going to allow you to prove your case without this element, and even with the plaintiff's counsel saying, Judge, I'm fine with that. That's what in the dissent the court noted. Even with that, a majority of the court felt it was so important to have proof of that element of the offense that it didn't matter that the plaintiff's counsel said that. It was still reversible error.
But and again, I think that's important because for our listeners, we are going to have a subsequent podcast on what you need to do to properly preserve your objections because so many people aren't doing that correctly.
Absolutely.
And this started to get to that. The dissent hooked onto the fact that it may or may not have been preserved correctly. So we'll have an entire subsequent podcast on that. But if you're reading the dissent in this case, you want to know that was out there. And I think that was very important.
And Kevin, real quick, I was reading about that case, and I do want to quote what the court said. The court said that, quote, a stipulation of fact wasn't filed or submitted to the jury, end quote. What exactly does that mean?
Yeah, that's a great question because, the court is using the word stipulation throughout, but then in a part of the opinion it says a stipulation of facts was not filed. And here's the thing. If you look up the dictionary definition of stipulation, if you look up, for the listeners, you look up Black's Law Dictionary and you look up stipulation, you'll see this definition. It says a stipulation is a voluntary agreement between opposing parties concerning some relevant point, especially an agreement relating to a proceeding made by attorneys representing adverse parties in the proceeding. So, Lauren, when the court said there was no stipulation of facts, they were thinking about the dictionary definition of a stipulation. And what that would be an agreement between the parties where there's a actual document filed with the court saying, Judge, the parties have discussed this before trial. And we're agreeing on certain facts and the way certain things should be, and even sometimes some evidence should be admitted to. But that wasn't this case. This was what we'll call a unilateral stipulation. This was one party saying, Judge, we're saying that we're conceding this point, And because of our concession, we're imposing that on the other side. So what the court was doing was it was trying to say this is different from where the parties agree to certain facts and to the admissibility of certain evidence. This was a situation where just one party was trying to have their way.
Gotcha.
Yeah, so I think that's a really good summary of the Davis case. Before we move on, Kevin, it seems like we've covered anything else that we need to add from that particular one. Are we good? You think our listeners got a good understanding of Davis at this point in time?
No, I think that covers it.
Yeah, so if you're listening, what we had the Davis case, and that very specifically said the defendants can't make you stipulate away a part of your case. Now, you might want to. There may be things that you want to stipulate to, and you always need to make that decision, but they can't force you to. They can't come in and say, we're going to admit liability, and therefore we have to keep out all this evidence. You have the right to prove every element of your case. And with that said, I think it's time to move on to the next case. Remember, we did tell you that there were two cases, and the second case that we need to deal with is MV Transportation, Inc. versus Allgaier. Kevin told you that was a 433 Southwest 3rd, 324. So we're going to get in and talk a little bit about Allgaier now. And I'll start out by giving you some real brief versions of the facts. This is a pedestrian case. There was a pedestrian who was in a wheelchair, and they were getting off one of the TARC buses, the smaller paratransit TARC buses for those in our community that have these disabilities or special needs. And they were injured while doing that. While doing the process of getting off that bus, they sustained very, very serious injuries. And there were a lot of questions about did TARC follow their policies and procedures? Was the person an employee? Ultimately, there were claims brought for respondeat superior, for they were an employee acting within the course and scope of their employment at the time, but also some negligent hiring, retention, supervision type claims. And the big issue from the case is what evidence would come in. The defendant wants to stipulate away. They want to say we admit that person, the TARC bus driver, was an employee. We want to admit that that's true, stipulate to that part of the liability, and therefore all this other evidence doesn't get to come in. It's a lot that they want to stipulate there. How does the court handle that, Kevin?
Well, and so to follow up on the Davis case versus this case, in Davis, the defendant was trying to stipulate away one element of the claim. In that case, malicious prosecution and the element of dismissal. In MV Transportation, the defendant is seeking to eliminate an entire claim or set of claims by allowing one other claim to go through. So what the defendant argues is this. Well, look, Judge, we will stipulate that MV Transportation is liable for the driver's conduct through what Rob referred to as respondeat superior, vicarious liability. And because we're stipulating to that, Judge, all of these other claims that the plaintiff alleged, what are called direct negligence claims, negligent hiring, retention, training, that sort of thing. All of those claims go away, Judge. They're duplicate. Those are duplicate claims for the vicarious liability claim, so the jury shouldn't hear any evidence pertaining to those claims, and we should just go forward with the vicarious liability claim. So that was the issue.
And that would have ruled out a lot of evidence that the plaintiff may choose they want the jury to hear.
That's exactly right. And in this case, there was a punitive damage claim that was alleged. And at the trial court, the trial court actually dismissed the punitive damage claim. However, the trial court said, even though I'm dismissing the punitive damage claim, I'm still going to allow the jury to hear evidence of all the claims. If you have proof of those claims, I'm going to allow it to go to the jury. So the jury received evidence not only of the vicarious liability claim, but also the direct negligence claims against MV Transportation. and a jury verdict. The jury came back, of course, in favor of the plaintiff.
And ultimately, the trial court got that right.
That's right.
They got that.
The trial court, as it turns out, got that right. Once the Supreme Court decided, it said, yeah, that's right. The Court of Appeals, of course, it went to the Court of Appeals before it got to the Supreme Court. The Court of Appeals also agreed with the trial court, said, no, defendant, you can't stipulate away all these other claims just because you agree to one claim. But when you read MV Transportation and you look at that analysis, you'll see that wasn't clear at all, because this was an issue of first impression in Kentucky. And other states were pretty evenly split on this issue. So if you look at, and we brief, I wrote an amicus brief on this, but
let me interrupt you and comment just briefly on that, because you're getting ready to talk about pretty detailed how the court had to go through what other states did.
Correct.
And I just want our listeners to know, you actually wrote the amicus brief on this. You actually got involved in this case.
Right.
As an amicus, and I think everyone knows what the amicus briefs are, but so you have a big background in that. So go through it for me a little bit.
Yeah, so this case finally reaches the Supreme Court on discretionary review. So when cases are, when the Supreme Court grants a case on discretionary review, that's a pretty big deal. They're going to really do a deep dive into the facts and legal issues in that case and kind of work through it. So, I thought it was an important issue to, for the Kentucky Justice Association to get involved and file an amicus brief, and I volunteered to write that brief. But one of the cases that I cited, I think it was the first case I cited, was Davis versus City of Winchester,
where we started today.
Just right where we started, to say, look, this isn't, even though there's a split in authorities in the states and even federal courts that had considered the issue, Kentucky had a case already that says you can't stipulate away an element of a claim. So it follows that if you can't stipulate away an element of a claim, you can't stipulate away a whole claim. So that analysis didn't end up in the opinion, but I think it helped the court at least orient the court to, okay, well, this isn't something that's completely unknown to us. We've been here before, maybe in a slightly different context. But in the analysis, and you'll see this in Justice Venners wrote the opinion. Justice Venners did an excellent job kind of going through how other states handled this issue. Actually, Justice Venners, it said in the footnote, each side claims that they have the majority rule here. He says that's a little unusual, He says, but we don't really look at, we don't decide cases by saying, 26 states did this, 24 states did this, so we're going with the 26 automatically, just numerically, that's better. We look at the purpose behind, we look at how other states handled this, yes, but just having the majority rule doesn't sway us one way or the other. We're going to look at the policy reasons for it. So,
and I thought that was interesting in the opinion that Justice Venners said, I can't, in this opinion, even state what the majority or minority opinion in other states is because it's such a split of authority. I just can't tell.
That's right. And I could say just based on my experience, it was difficult to find there's a clean, because there were several different ways courts handled this issue depending on the circumstances. For instance, some states would say, okay, we're going to follow this, what the court calls the preemption rule, and it's basically the stipulation approach. But some courts say we're going to follow that rule unless punitive damages are alleged. Right? And some say we're going to follow the preemption rule whether punitive damages are alleged or not. So it became very fact dependent, and ultimately that's why Justice Venners said at the end of the day said, that doesn't really make a whole lot of sense. Why should it depend on punitive damages being alleged, whether you stipulate whether a case is wholly eliminated just because you allege punitive damages? And Kentucky, under the Kentucky civil rules, you can plead multiple claims for a given set of facts, even pleading in the alternative. So Justice Venners in the opinion goes through that analysis and says, given Kentucky's tradition and our civil rules and our way of approaching modern tort law, the better rule is to not allow this stipulation or preemption rule.
Yeah, and let's make sure our listeners understand that, because I've been in cases where the defendants have said, we want to stipulate away this part, and if I didn't have a punitive damages allegation, well, Judge, they were texting and driving. Judge, they were on their phone. Or Judge, they violated these policies and procedures. That would lead to something perhaps where I could ask for punitive damages, which all that evidence may go to that. Under this opinion, it says, look, it doesn't matter. They just cannot force you to stipulate away either an element of your claim or an entire claim itself under this particular opinion. Kentucky's going to follow the rule. You can't stipulate away regardless of that claim. So I bring that up because as defense counsel make those arguments against you, just know Kentucky said we're going to adopt the rule that it doesn't matter. Is that accurate?
Yeah, that's accurate. And what's interesting about this opinion is we were talking about that the trial court had actually dismissed the punitive damage claim. So this case reaches the Supreme Court. The way it was postured was it was just the compensatory damages that went to the jury, and that was all the jury awarded. So when Justice Venners does this analysis, it's only based on liability and compensatory damages. He says the preemption rule, that stipulation approach, doesn't apply even then. So that's very important. It didn't matter whether punitive damages were asserted or awarded or anything else. But I do want to add the opinion, so this is just north of a $4 million verdict. The court says, you know what, the trial court did err in one respect by dismissing the punitive damage claim. So we're going to remand that part back and send it back for a limited retrial just on punitive damages.
Yeah, and I think that's important because for our listeners, that's outside of the question, can they stipulate away a part of the case? The answer is clearly no, they can't stipulate it away.
Correct.
The court also addressed the fact that there was enough evidence there for a jury to decide the punitive damages issue, kind of as an extra issue outside of our podcast today, but as an important issue as a practitioner, practicing law in the state of Kentucky. Is that?
That's exactly right. Yeah, that the punitive damages did go back for a limited retrial just on punitive damages after this opinion.
Now, I did notice, I think it was on page 8 of the opinion, where the court said, quote, a finding of gross negligence in an award of punitive damages may be based, at least in part, upon evidence regarding the policies and procedures of the company, end quote. This seems to come up a lot. Can you address this, Kevin, for our listeners?
Yeah, and that part of the opinion is a really solid, like the rest of the opinion, is a really solid analysis and a deep dive into the issues. But yeah, this issue does come up a lot, and I get this question, quite a bit. It's like, well, I want to get in evidence of policy of the company's policies and procedures, and the defendant is telling me I can't do that. They filed a motion in limine, and they say that's just not possible. MV Transportation clarifies that. It says, yeah, you can get in evidence of policies and procedures to support a claim of punitive damages, and so this case you should be looking at this case for multiple reasons. Obviously, the stipulation approach, the policies and procedures evidence, punitive damages, negligent hiring, retention, and direct negligence claims. It covers all of those fronts.
And I'll tell our listeners that Kevin and I have decided that one of the future, not two in the future, but one of our future episodes, we're going to address what is the admissibility of policies and procedures and violations of those policies and procedures, because it is starting to come up a lot. So I'm sure we'll have an opportunity to come back to that.
Yeah, that'll be great. I think that'll be because that is an important issue. I mean, fights over policies and procedures is just a common fight these days. Defendants don't want it in, plaintiffs do, and so it's just something trial courts hear quite a bit of now.
So to the specific question that we're addressing today about can they stipulate away or make you stipulate away any facts, have we covered the analysis of that case, or is there anything else that we need to?
No, I think based on Davis and based on MV Transportation, we can safely say two things. One is that a defendant cannot unilaterally stipulate away an element of the plaintiff's claim, and a defendant cannot unilaterally stipulate away a plaintiff's entire claim. So those two cases, Davis and MV Transportation, are the cases you need to look at if you're ever confronted with that situation where a defendant tries to stipulate away, or say, Judge, I agree, or I'm going to stipulate liability, or what have you. You need to be looking at those cases to come back to the judge and say, Judge, even though they stipulate this, that doesn't affect the evidence that I'm going to admit to prove my case.
All right, well, listeners, I think we've got a very clear answer to the question. Lauren asked us at the very beginning, can they force you to stipulate away your case? The answer is no. They can't come in and say, we're going to stipulate liability, therefore a bunch of your evidence doesn't come in. You have the Davis case that says they can't make you stipulate away an element of your claim, right? Duty, breach, causation, damages. You have the MV Transportation case that says they cannot force you to stipulate away an entire cause of action with the preemption rule, etc. So I think we got a very, very clear answer to that one. I will let our listeners know that this is episode 3. We will have episode 4 coming out soon, and you'll really want to tune in for that one. In episode 4, we are going to discuss the Fratsky opinion, and I hope most of you all know what the Fratsky opinion is, but you may not understand the progeny of that and different remedies for when you have not timely filed. So you definitely want to tune in to our next episode. Again, Fratsky will be episode 4. I hope everyone enjoyed this episode of The Legal Notepad. I want to personally thank each of you for tuning in today. And if you would like to hear more of these episodes, you can find us in a variety of places. You can go to our website, DeCamillisMattingly.com. You can also find us on Spotify, Apple Podcasts, Google Podcasts, iHeartRadio, and many others. I'm Rob Mattingly, along with Kevin Burke and Lauren Hincks. Until next time, we all want to challenge you. Go find one thing you can do to change the world. And just a reminder to all of our attorneys, these podcasts are always free. But if you want to obtain CLE credit, the Kentucky Justice Association has worked with the Kentucky Bar Association for approval of the CLEs. Again, to get that credit, you simply go to KentuckyJusticeAssociation.org. That's the KJA website. Click on Education and Training, select Podcast, and add it to your cart.